Thugger Daily is giving us two new updates. So, hot off the presses, we have a recusal motion update. This is for the recusal motion of Judge Rachel Krause. She has denied this motion. And Judge Rachel Krause also issued a separate order denying Yak Gotti's motion filed by Doug Weinstein and co. to recuse all Fulton County Superior Court judges from ruling on the recusal of Judge Glanville. We'll start with this Fulton County recusal. You can see that it was just filed 402. So shout out to Thugger Daily. And I do have their Cash App in the little banner ticking across the bottom of the screen. Let's first look at this order denying motion to disqualify Fulton County Superior Court judges from ruling on recusal of Chief Judge Glanville. This case was randomly assigned to this court to consider certain motions to recuse Judge Glanville from further proceedings in the case. On July 2nd, 2024, defendant Diamante Kendrick filed a motion to disqualify the Fulton County Superior Court judges from ruling on the recusal motion for Glanville. A motion to recuse must be timely and accompanied by an affidavit stating the facts and reasons that bias exists and recusal is necessary. And they cite USCR 25.1 and 25.2. Importantly, quote, allegations consisting of bare conclusions and opinions shall not be legally sufficient to support the motion or warrant further proceedings. When a judge assigned to a case is presented with a recusal motion and an accompanying affidavit, the judge shall temporarily cease to act upon the merits of the matter and determine immediately 1. Whether the motion is timely, 2. Whether the affidavit is legally sufficient, and 3. Whether the affidavit sets forth facts that, if proved, would warrant the assigned judge's recusal from the case. If all three criteria are met, another judge shall be assigned to hear the motion to recuse. And that's that Mondi v. Magnolia Advanced Materials case we've seen several times. Assessing whether these three criteria are met does not involve an exercise of discretion by the judge whose recusal is sought, but is a question of law to be determined by the assigned judge. So in other words, this is Rachel Krause writing this, Judge Rachel Krause. It's not discretion that she's using here. It's a question of law, and she's giving us her determination now. Assuming, without deciding that defendant Kendrick's motion is timely, it is not supported by an affidavit of any kind as required by Rule 25.1. Therefore, the motion is due to be denied. And they cite here Huff v. State, which found that the trial court properly denied a motion for recusal unsupported by an affidavit, as required by USCR 25.1 and 25.2. Defendant Kendrick's assertion that Judicial Qualification Commission Opinion 220 requires recusal of the entire Fulton Superior Court bench does not save the unsupported motion. In Opinion 220, the JQC opined that it is inappropriate for any trial court judge to preside in any action wherein one of the parties holds a judicial office on the same or any other court which sits in the same circuit. But Judge Glanville is neither a party nor counsel in this criminal prosecution, nor is this a mandamus action, and defendant Kendrick cannot make it so by filing a recusal motion. Furthermore, defendant Kendrick's motion ignores the clear directive of the Uniform Superior Court Rule 25.4. That rule directs that, in a multi-judge circuit, like the Atlanta Judicial Circuit, a recusal motion shall, and they're bolding it, be assigned for hearing to another judge, and the selection shall be made by use of the circuit's existing random, impartial case assignment method, which in this case, it was the Odyssey, the system that they use. That randomly assigned this to Judge Krause. Defendant Kendrick's motion to disqualify the Fulton County Superior Court judges from ruling on recusal of Chief Judge Glanville lacks an affidavit and fails to satisfy the requirements of USCR 25.1 and 25.2. Additionally, defendant Kendrick's asserted basis for recusal, even if supported by an affidavit, would not warrant recusal in light of USCR 25.4. Therefore, the motion is hereby denied, and it's so ordered on this day, this 9th day of July, the Honorable Rachel Krause. And in a way, now that we flip over to the other motion, she's not disqualifying judges from the Superior Court of Fulton County, and she's also not going to recuse herself, which that's kind of self-encompassing a little bit. There's a little bit of overlap. But we do get some additional arguments in this other motion. So, order denying motion to recuse Judge Krause from hearing recusal motion. And again, we're getting that reiteration that this case was randomly assigned to this court to consider certain motions to recuse Judge Glanville from further proceedings in the case. On July 8th, 2024, defendant Jeffrey Williams filed a supplement, so we're getting it acknowledged already. This thing that we just read today, that 200 and something page document once you consider all the exhibits. I'll link to that in the description, but she's already incorporating that into this response. On July 8th, 2024, defendant Jeffrey Williams filed a supplement to motion to recuse Judge Glanville. Though titled supplement, a portion of the filing seeks to recuse this court from hearing the recusal motions. Now, we're going to see why this July 8th supplement sticks out to Judge Rachel Krause. This court, therefore, must consider the portion of the supplement seeking this court's recusal before proceeding further. When a judge assigned to a case is presented with a recusal motion and an accompanying affidavit, the judge shall temporarily cease to act upon the merits of the matter and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if proved, would warrant the assigned judge's recusal. And here we're getting a footnote to acknowledge a change. So on July 9th, 2024, defendant Williams, so their attorneys Steele and Adams, filed an amended supplement to remove an assertion in footnote 2 of the original supplement. This is talking about that $500 campaign donation. And continuing, we're getting the citation that paragraph, that was from Mondi versus Magnolia. And assessing whether these three criteria are met does not involve an exercise of discretion by the judge whose recusal sought, but is a question of law to determine by the assigned judge. Now we're going to get into this information and the footnote 2 on page 1 of that supplement. Defendant Williams' motion in footnote 2 and later, a lengthy paragraph 52, asserts two bases for recusal of this court. Defendant Williams asserts that recusal is merited because of a $2,000 donation made by Judge Glanville to this court's recent re-election campaign. Defendant Williams also asserts that recusal is required because, quote, it is inappropriate for any judge to preside in any action where one of the parties holds a judicial office in any other court which sits in the same circuit. Defendant Williams' supplement seeking to recuse this court is supported by an affidavit, albeit only footnote 1 and paragraph 63 as to this court, and it was filed within 5 days of this court being assigned to handle the case. Therefore, the first two criteria are satisfied. It's timely and there's an affidavit. And the only consideration for the court is whether Judge Glanville's campaign donation to this court re-election campaign warrants recusal. The Georgia Supreme Court has held that the mere fact of a campaign contribution to a judge, even from a party to the case, does not warrant recusal where the contribution was not exceptionally large. And so here we're getting a citation for Jude, maybe it's Good versus State in 2011, and then Woodham versus Atlanta from 2015, which affirmed the denial of a recusal motion based in part on a campaign contribution from one of the judge's colleagues on the court who had recused from the case. And then we also get Post v. State from 2015. Allegations of unexceptional campaign contributions or commonplace support during a judge's election campaign ordinarily are insufficient to require referring a recusal motion for reassignment to another judge. The Code of Judicial Conduct reiterates this point, noting that when a campaign contribution is less than the maximum allowable contribution permitted by law, an affidavit seeking recusal must allege additional facts demonstrating the need for recusal. In summary, Rule 211A4 provides that 1. If contributions made to a judicial candidate or to that candidate's campaign committee are permitted by law and do not exceed the maximum allowable contribution, then there is no mandatory requirement that the judge recuse. Because under Georgia law, the asserted campaign contribution would not warrant recusal, and defendant Kendrick has not alleged any additional facts demonstrating the need for recusal. And I was waiting for this. He has not met the third criteria for recusal. So I was actually thinking this. We know that Doug Weinstein has made an affidavit. Doug Weinstein, Katie, J. Apt, they have filed an affidavit. Doug Weinstein signed the sworn affidavit. He did that on a separate motion, but there wasn't an affidavit attached to this motion to disqualify the Superior Court judges. That 2-page motion we just looked at, Krause is like, you guys didn't attach an affidavit, and then the specific rule you're citing isn't exactly enough. It doesn't get you there. So I personally read the first one we went through. Maybe she's kind of nudging that this could be met if you attach the affidavit and try another route to get yourself there. And then here in this motion, it's almost like she's repeating that. She's nudging again. Defendant Kendrick has not alleged any additional facts demonstrating the need for recusal. So he has not met the third criteria for recusal. We've really got this fact being asserted on behalf of Jeffrey Williams that, hey, this campaign contribution is why you should recuse. So Judge Krause is saying, well, as a matter of law, no, this is what the case law says, and I don't have anything else to work with. So I'm not sure if she's really slamming the book down all that hard, or if she's just saying, try harder. But in any case, it doesn't seem like she's thirsting to get herself recused or get herself off this case. Do you guys think she wants to hear this? How badly do you think she wants to hear it? And do you think which direction? Why do you think she wants to hear it? If so, let me know your thoughts. Her order goes on to say that Defendant Williams' additional assertion of Judicial Qualification Commission Opinion 220 in support of this motion is unavailing for two important reasons. First, Judge Glanville is neither a party nor counsel in this criminal prosecution, nor is this a mandamus action, and Defendant Williams cannot make it so by filing a recusal motion. So, Opinion 220's conclusion that a judge should not preside in an action where one of the parties holds a judicial office in the same circuit does not apply to the circumstance. So they cite here, compare Georgia Transmission Corps v. Dixon and Smith v. Guest Pond Club. So a 2004 and 2003 case where judges were either parties or counsel in the underlying civil case being heard by a judge in the same circuit. Second, and perhaps most importantly, Defendant Williams' motion ignores the clear directive of Uniform Superior Court Rule 25-4. That rule directs that, in a multi-judge circuit, like the Atlanta Judicial Circuit, a recusal motion shall be assigned for hearing to another judge, and the selection shall be made by use of the circuit's existing random, impartial case assignment method. So again, this used the Odyssey system, right? And then they also give this footnote, notably in a two-judge circuit, a recusal motion as to one judge is heard by the other judge. So it would be normal in a circuit where there's only two judges, the one that's not being asked to recuse has to hear the recusal motion for the other one. So why should that be any different here? There's more judges available here, and I was assigned randomly. There wasn't a particular reason why I was assigned. This court does not relish the task to which it has been assigned, but it is as much the duty of a judge not to grant the motion to recuse when the motion is legally insufficient as it is to recuse when the motion is meritorious. And that is coming from Jones County versus A Mining Group, LLC, and also Hampton Island Founders versus Liberty Capital. For the foregoing reasons, the portion of Defendant Williams' supplement and amended supplement seeking to recuse this court is hereby denied. It is so ordered this 9th day of July, 2024. And Joseph Papp, even though we've read through it, actually uploaded the document. So I'll link to his Google Drive links in the description as soon as I get this published. And yeah. So what do you guys think? I mean, do you think that was a hard book slam, like, haha, screw your efforts here, defense counsel? Or do you think it was like, hey, I'm looking to apply the letter of the law. I'm looking at what the case law says. I personally don't know much about Judge Rachel Krause. So for me, I don't really have a lean either way. I do think that it could be genuine that she's saying I don't relish in the idea of wanting to be the one deciding if another judge, one of my fellow judge that I see every day, should be recused. And on the flip side, I also see concern of, these people know each other. Maybe they have biases that they're not aware of. Can they be impartial? So I see it from both sides. And remember, neither of these things are a denial of the motion to recuse Judge Glanville. They are a denial of the motion to recuse Judge Rachel Krause, and a denial of the motion to disqualify Fulton County Superior Court judges. So this is not the be-all, end-all of, is Judge Glanville going to have to recuse or not? We're still waiting on the state to file their response. They have until tomorrow, Wednesday, at 5 p.m. to do so. So again, shout out to Thugger Daily for this update. It came right across the Twitter notifications. AV to the 7th Power started talking about it. I'll link to that stream. I think they'll probably still be live when I'm done with this. So I'll link to that in whatever, so that way you guys can hop over there. And now that Joseph Papp has given us the actual PDFs, shout out to Joseph Papp. I'll link those in the description and everybody's X accounts as well, so that way you guys can go follow them. Let me know your thoughts, you guys. Turning the floor over to you. Busy day, huh? You guys all have a good one. Take care.